Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
We can see this morning. Well, good morning, everybody. Welcome to the Pleading of the United States Court of Appeals for the Fourth Circuit here at Carolina Central University. We are law. We're so happy to be here this morning. Look forward to interesting morning that I bring. Part of the word. So we'll begin with our third case. 23-46 people. United States versus Wright. Mr. Long.
Good morning, Your Honors. Aaron Wellman arguing for appellant Brian Wright. May it please the court. Mr. Wright was sentenced in a conspiracy case last year, a drug conspiracy case involving an indictment with 8 defendants on it. Mr. Wright pled guilty to the object of the conspiracy involving distribution of fentanyl. At sentencing, Mr. Wright his sentencing level was enhanced by the application of an aggravating role enhancement for a managerial role. The pre-sentence report and the government and ultimately Judge Biggs agreed that 3-point enhancement would be appropriate, that the scope of criminal activity was widespread or extensive, whereas I argued that a 2-point enhancement would be appropriate and that the criminal activity involved was small scale.
How many participants did the district court find were involved with?
I don't believe that the district court made a specific finding as to the exact number of participants or comments on.
My reading of the record, it seems that the district court perhaps found that appellant conspired with, quote, Brown, Diaz, Ferguson, and McDougald. I'm not sure if I'm pronouncing that correctly. So, would you, is this finding clearly erroneous, or are you arguing that the finding, if there was a finding, was not clearly erroneous, but instead that the enhancement just shouldn't apply?
I'm arguing that any finding that there were 5 or more participants in my client's criminal activity was clearly erroneous.
Okay. And based on what I read, if you count your client, then that would be 5 or more participants. But your argument is they didn't participate in the criminal activity to which appellant pled guilty, correct?
Not quite, Your Honor. I believe you can't dispute that my client pled guilty under a Pinkerton conspiracy liability sort of sphere of activity. However, the sentencing guidelines have not adopted that as far as sentencing liability as opposed to criminal liability.
You know, you need to clarify first how the guidelines should be interpreted, because I think you are relying quite a bit on the commentary. There's some confusion as to what is effective commentary. Well, if you find the guidelines to be unambiguous in the campus. So that's kind of where you got to get us, at least in terms of the law, which of those, the direction we go in. The guidelines come into play, are they clear, unambiguous? If so, then at least on the Campbell, we don't need to look at commentary. But you want us to look at commentary. Is that correct?
Your Honor, regarding the 3B1.1, I don't think it's necessary at all for us to look at the commentary.
Because it's not ambiguous, correct?
I don't believe it is ambiguous at all. It pretty clearly as to talking about criminal activity only. I think that language is if we look at B, 3B 1.1B, if the defendant was the manager or supervisor, any criminal activity involved 5 or more participants. So the commentary is what muddles everything, because then it starts talking about what is a participant. If we leave out the commentary, which again, I don't think there's really any ambiguity there, we're talking about criminal activity. And that, once we go back to the
criminal activity is pretty broad. That's the problem, I would think, if you're saying it's unambiguous. It's the determination of criminal activity, not necessarily participants or otherwise extensive part of that would be guideline. It's a question of criminal activity. And where do we turn for that? If we don't look at the commentary, there's another section in there in the guidelines that talks about joint type criminal activity. Why does that not come into play here? To make it clear that it is a very broad interpretation that would include up to the 8.
Your Honor, that language, criminal activity, and if we go to the beginning of the relevant conduct guideline 1B 1.3, and there you see it again, the discussion of which criminal activity is a defendant going to be liable for in sentencing. I think some of the fuzziness is that the commentary leaves that.
In the sense of criminal activity which you convicted, then there's a sentencing aspect of it. Sentencing is different. And the court, at least the cases are pointed to, that you necessarily have to be directly involved with the other activities here in order for it to be part of conspiracy, if it is part of the overall scheme or the scope of it.
I think it has, in order to be liable in the sentencing sense, it has to qualify as relevant conduct.
So that's the issue.
Doesn't our recent case, Evans case, help you?
I read it. It was one that that I had not cited. I took a look at it.
I think it was probably asked, yeah.
Yeah, and to me, when I took a look at it, I found it to be generally in support or to help me in terms of.
Right, I think it might too, because there we said the district court must make particularized findings under 1.3 when the criminal activity supporting the sentence is a conspiracy, which sounds like what we have here. And the district court, did the district court make particularized findings?
Not as to that 1B 1.3 relevant conduct analysis, whether the.
Yes, sort of where you and I started, that the district court, it's hard to tell if the district court made a finding or not about what the criminal activity might have been and who would have been involved.
Your Honor, I agree. To me, it
I mean, you could just stop it. I agree. As far as I'm concerned.
So let me ask you about that. So if you agree, I think it's wise for us to agree, always wise to agree with the fact that, so where does that leave us? Is your argument that the record is insufficient as a matter of law and warranty enhancement, or is your argument that whether or not there's evidence in the record to support it, this report has a record to supply?
Your Honor, my argument would be that the record does not support any finding that this criminal activity, relevant conduct criminal activity, included 5 or more participants.
So, what's the remedy? They gave the remand or outright reversal because of the lack of evidence.
Your Honor, what I'm asking for is a remand or resentencing on the with a recognition that the record is simply is not.
So without another bite at the apple by the government to attempt to apply.
That's right.
So the guideline for the issue here, I understand it's 3B1. When we look at Evans limited to particularized findings for 1B 1.3 and not 3B 1.1.
Well, Your Honor, that 1B 1.3 assessment as to relevant conduct, it applies right there in 1.3A to adjustments, I guess, adjustments in chapter 3. So by the plain text of the guideline are the assessment of does the aggravating role in chapter 3 apply is undertaken as a part of relevant conduct.
My question is, George, are we looking at the criminal activity definition as it exists under 3B1.1? And that being the case, Evans did not address 3B1.1, it addressed still 1B1.3. So how does that inform or control our decision in this case?
Your Honor, I take it that we're sort of distinguishing here between the drug quantity calculation, which we see over and over again, where it is limited by the relevant conduct consideration, and that is something that's taken up in 1B1.3, and it's in the commentary and so forth. But the fact that Chapter 3 enhancements, that's not part of the assessment of drug quantity. Chapter 3 enhancements.
I'm just trying to make sure we're clear. It seems me, question me, whether this 3B1.1 counts participants are only which you contend the defendant was directly aware of. But to get that answer, we have to determine what does the term criminal activity mean under that particular guideline. And there, it sets it forth pretty clear, at least in my perspective. But then you turn to Evans, which deals with the particularized findings under a different guideline of 1B1.3.
Your Honor, I would state that the definition of criminal activity is used in one place in the guidelines and another place in the guidelines should be consistent. And there's no reason why in 1B1.3 the defendant's criminal activity is defined in terms of relevant conduct, whereas
just asking that point because they are saying why is it that in 1B1.3 the words jointly undertaken is added to the term criminal activity, so these jointly undertaken criminal activities as opposed to criminal activity in the other guideline. What is the significance of that? Or is that just a purpose language?
Well, I don't know that any language is strictly superfluous. But Your Honor, I would, in the circumstance where it is modifying criminal activity in 1B1.3, it is necessary there in 1B1.3 to distinguish the jointly undertaken criminal activity from the singly undertaken activity that's addressed in A1A as opposed to A1B, whereas that modifier is not necessary in the aggravating role enhancement language because by definition we're talking about some type of jointly undertaken criminal activity.
Can I ask you about the different ways that government can make out this enhancement? You, the Stafford, had a policy about the number of participants. Thankfully, that hopefully it was not the prosecution for lawyers and time. That's not the only way that the government can prove the full 3-point enhancement. But they also show that the activities were otherwise extensive, right? Is there any evidence on that point? Is there any argument that we have in the president? Should the government report have another opportunity to see what the evidence supports that option?
Your Honor, I would argue that the government is bound by the information presented in the pre-sentence report as to the offense conduct, the offense relevant conduct. It is a factual assessment as to whether the facts as alleged qualify under Fourth Circuit case law as otherwise extensive. In this
But the
case,
district court didn't find that in the sentencing, correct?
not to
That's
my
another
detection.
thing that perhaps on remand the district court could look at.
I think the district court certainly would have the opportunity, should have the opportunity to look at that. I don't think that's true of the number of participants because that's a number. Not at this time. I appreciate your honor questions. Thank you very much.
Thank you, Your Honor. May it please the court, Julie Niemeyer for the United States. The district court properly applied the three-level role adjustment to Mr. Wright for his supervisory role in a poly-drug conspiracy that involved 8 participants. No clear error occurred. There's 2 different bases on which this court can affirm the district court. First, there is simply no indication in the guidelines, in the text or commentary that would support this limited interpretation that Mr. Wright suggests of the term criminal activity. And without any limiting characterization of that term, the criminal activity should be evaluated in a broad fashion. And in here we have
state of it all, how we should deal with guidelines of the commentary. That is, I say, under the police.
Well, Your Honor, I think here in this case, we don't really need to reach that issue because I think the guidelines are very clear. And to the extent there was any ambiguity in the guidelines, the court is permitted to look at the commentary. That's well within the court's discretion. And here, the guidelines do not place any limit on the term criminal activity. If we look to section 3B1.1, there's 2 parts to a role enhancement. The court first has to evaluate what was the defendant's conduct, what type of role did he play, and then that has to be evaluated against the backdrop of what arena was the defendant operating. So that's how these 2 guidelines work together: the aggravating role guideline and the mitigating role guideline.
You're suggesting that there's no daylight between those 2 propositions. Evidence suggests otherwise. There's a different set of assumptions and factor findings of liability under a conspiracy and one. And then in terms of sentencing, it's much narrower scope of analysis of the fact. Can you disagree with that?
Absolutely not, Your Honor. I think Evans just really clearly clarified that when we're looking at the relevant conduct to be attributed to the defendant, we have to follow those principles that are set forth in section 1B1. We have to look at what was jointly undertaken and what meets the criteria there. And those same principles inform the court's analysis of what role the defendant played. Those are of a piece. What role?
Aren't we talking about an adjustment under chapter 3? The enhancement is an adjustment, right?
Yes, there's a
All right. Well, it says right in the guidelines that adjustments in chapter 3 shall be determined on the basis of, and then it lists all the things in 1B1.
Yes, absolutely.
Which is what Evans is talking about. So I
Yes.
don't know how it doesn't apply.
It certainly does apply, Your Honor, because that's how we look at the defendant's conduct. The conduct is what makes up his role. So when we're looking at Mr. Wright's role, we're only ascribing his conduct under relevant conduct principles to him. We can't look at his role and say somebody else's transactions, should go into our analysis of his role. We're looking at his relevant conduct to determine what his role was.
Yeah, I think Mr. Long would agree with that. You see that sort of different definition of what his role was. Suppose while his role is much more expansive than what Mr. Bryan and Mr. Long want.
Well, Your Honor, he was a major distributor in this conspiracy. There were 6 people that were charged. Yes, Your Honor. There were
other drugs involved, right? You had nothing to do with it.
Right, Your Honor. But in this conspiracy, 6 people were charged with fentanyl and 2 were charged with methamphetamine. So here there were 6 people that were involved with fentanyl And
We can
Mr.
add 5, but we don't have.
And that includes 5 if you count health.
There was McDougal, Bright, Bush, Brown, Ferguson, who works directly under Bright, and also Jones.
And where does the district court say that?
So, Your Honor, at JA 58, kind of at the outset of the court's discussion, after Mr. Wellman had said his remarks, the court said, "I've got Brown, Diaz, Ferguson, McDougal."
Right. You
And so-
mentioned there's several other people there.
Right, because there were a couple others that he wasn't directly. There was one other
I'm
person,
trying
Jones.
to find where the court defined the scope of the criminal activity.
Well, there was that statement made on the JA 58, and then there were additional findings, kind of the concluding remarks made by the court at JA 62. The court says, "I don't think the law supports what you're asking me to do. I think what we have here, this gentleman had a fairly significant role in this conspiracy. He may not have known everybody that touched those drugs or everybody who distributed them, but that is not a requirement." It is a clarification of the law.
Why does that come up to either a number or a context extensively?
Well, Your Honor, because there were 5 individuals that were clearly in the court's mind there. There was Mr. Ferguson, who he directly supervised. There was McDougal, who Mr. Wright had most of his transactions with in the record. There was Mr. Brown, who in the factual basis is identified as someone that Mr. Wright directed to distribute fentanyl to McDougal and or the CI because he wasn't available. And then there's Diaz, and she had purchased fentanyl or heroin. Without.
That's no relation, right? You have the name client.
No, you're right. That particular defendant had also made a purchase from Mr. Bright in November of 2021, clearly within the scope of that timeframe of the conspiracy. And so there's 5 individuals right there that are all supported by evidence in the record, making that finding not clearly erroneous. Even if, though, we had not had 5 individuals, the evidence in the record would support an otherwise extensive finding as well.
But the district court didn't make that.
Did not make that finding. No, Your Honor. No.
Did the government ask the district court to make that finding? Did the government even argue that at sentencing?
I don't know if that was explicitly addressed, Your Honor. I think,
I don't see those words.
the primary argument was just that this is an
The primary argument, but I don't see those words anywhere in the sentencing hearing from the government, but I might be wrong. Oh, in the sentencing.
I think it was, the primary point made in that memorandum was that, there does not need to be a minimum number of persons.
Right, I know that was the primary point. My question was, did the government ever argue this otherwise, whatever the language is, argument, below at sentencing? Otherwise extended.
I don't think they did, Your Honor. The government said,
I didn't think so either.
5 or more people, this is J 61. The criminal activity involved 5 or more, and summarized the case law that whether a particular defendant needs to be involved with 5 or more folks, is not a requirement. There does not need to be direct involvement with those 5 people. But here, there's clearly evidence that there were 5 people involved. Indeed, there were more people involved.
People in 5 participants.
5 participants, yes, sir. I mean, the conspiracy involved 8 participants, but we have 5 individuals identified by the district court as record as having had fentanyl involved. And just to go back to Your Honor's point about the Evans case, I just think it's really important to frame this issue in terms of both the conduct of the defendant and the stage on which the defendant is operating. The conduct of the defendant, the government would never articulate that he should be attributed anything that was not authorized by Chapter 1 of the guidelines. The relevant conduct attributed to the defendant is what is used to evaluate transaction, his role in the conspiracy. But the broader stage on which the defendant is operating is the criminal activity as articulated in the guidelines. And we know that that is consistent with what is in the mitigating role guidelines. The same phrase is used in that guideline. The defendant's role analyzed against the overall criminal activity, the size of the organization. If that role is minimal, then they get a mitigating adjustment. So if Mr. Wright's theory that the role has to be evaluated in terms of only the people he had transactions with, that would make the mitigating role guideline superfluous. Because, of course, if the defendant's role was minimal, and let's say he had transactions with one other individual, okay, that wouldn't look minimal because we can only look at his little universe. The guidelines tell us to look at the entire criminal activity to determine whether his role was minimal. And similarly, here in the aggravating role guideline, we have to look to the whole criminal activity to determine whether the role was a more major role. And I think that's what
you make of the introductory concept.
Well, Your Honor, that ties back to what I was saying about how the defendant's conduct has to be evaluated in terms of Chapter 1, relevant conduct guidelines. We're not going to ascribe to the defendant anything that is not appropriate under Chapter 1. All of his relevant conduct goes into what was his role. And we've seen that in other cases too.
But then it also speaks to adjustment in Chapter 3.
Absolutely, Your Honor.
Which I thought we agreed an enhancement is an adjustment in Chapter 3.
Your Honor, I have to admit, the distinction between an enhancement and an adjustment is fading me at this time. But
right, there is no. I'm saying there is no distinction. An enhancement is an adjustment.
Okay. Yeah. Yes, Your Honor. Yes. And that enhancement is based on the defendant's conduct. The defendant's conduct is evaluated in terms of the guidelines, in terms of the criminal activity as a whole. The activity as a whole is the broader criminal activity, either a conspiracy or other enterprise, in this case, conspiracy.
Before the district court turned to this issue of managerial liability, we made a finding with respect to drug quantity.
Yes, Your Honor. Yes.
Found that Wright was accountable for 161 plus grams of fentanyl. And in doing so, the court said that Wright's relevant conduct only included his transactions with an illegal informant in which Ferguson assisted. So why isn't that the same relevant conduct with respect to the managerial enhancement? That's the case. We got 3 people, nowhere near the 5.
Well, I think the court almost always use kind of a conservative approach to ascribing drug quantity. And so the transactions where McDougald was purchasing from Brown at the direction of Mr. Wright, that I don't believe that went into his 161, but it certainly could. Appropriate findings had been made. But here the PSR went with the findings that were well documented by the CI. And I think that was the sound strategy.
Okay. Well, but I'm also struck by the fact that this court was very careful in that analysis there. And but when it turned to the attribution with respect to the vehicle and all the consumers, general comments, you kept characterizing this finding, but I think that's over the
Well, yes, Your Honor. Yeah, well, it's important to remember that here the actual goal was not in dispute. So Mr. Wright was not disputing that he had a supervisory role,
Right.
even at that. So the only dispute was over the number. Yes, Your Honor, the number of participants. And I think the court, by its introductory remarks regarding, the 5 people being involved in fentanyl and the discussion of this being a large conspiracy, was convinced from the outset that numerosity requirement had been met.
If we were to disagree with you and find that there was a mistake made, I think we asked you all to talk about whether or not that mistake could be considered harmless in the context of this case.
Yeah, wait, Connor.
You don't think that. So either you win on the merits of the argument, it's like that.
I agree with that, Your Honor. If there are no further questions, the government would ask this court to affirm.
Thank you very much. You on?
Yes, Your Honors, trying to be brief, and just sort of, address, and I was somewhat, I think that, the court's initial question was sort of, did the judge decide how many participants there were? And I said no, and the reason for that is because when I look at, the judge's comments on Joint Appendix page 58, where she says, I've got Brown, Diaz, Ferguson, McDougal, I agree with Your Honor that, you know, these are comments during my own argument where she's asking, where the Judge Biggs is asking me, well, what about this? What about this? And I'm responding. To me, that is, you know, never, I looked at that, I never considered that to be a finding of fact. And I don't think Your Honors should either. As for,
So in that regard, the Judge Biggs made that finding for that statement. Did you make any objection? Was there any? What the judge was doing?
yes, Your Honor, I pointed out that in the pleadings, pre-sentencing pleadings and my objections that I filed, as well as my pleading on the objections of position paper that we were disputing any of Mr. Bright's relationship or interactions with either Mr. Brown or Ms. Diaz, both of them. And I pointed that out to the judge immediately when she put their names in.
And to be fair to both the parties and the district court, nobody had benefit of Evans at that time, at the time of sentencing, correct?
I don't believe so. Your Honor.
Right.
The only other
What's
thing.
your response to Nick Niemeyer's argument that your reading here would make the mitigating role guidelines superfluous?
Your Honor, I don't see it. I think each case stands on its own. Relevant conduct, you know, part of the way that these guidelines work and the idea of relevant conduct is that sometimes relevant conduct is going to be greater than the criminal offense, and sometimes it's going to be more narrow than the criminal offense. And that's going to affect the enhancements for if we start from the homeland of relevant conduct. I don't think that we can blanket, I mean, we can say with a blanket statement that, oh, that means in every single case, somehow there's going to be a limitation on the number of participants. And most of the time, it's the government that is benefiting from the fact that we don't, that the guidelines aren't addressing offense-specific conduct. They're addressing not offensive conviction conduct. They are addressing offense conduct overall. And most of the time, it's the government that's benefiting from that. And I just go back to the case that I've referenced a couple times in my briefing, which is Fells. That was not a conspiracy conviction in 1990. That was not a conspiracy conviction. It was a distribution conviction.
How significant do you view evidence in this case? Is that a case that has a positive impact on us forward in terms of outcome?
Your Honor, I think Evans clarified, you know, where we are as far as there.
Did you discuss this with us before that?
I have not, Your Honor.
Give us a 28-day leverage.
I did not. Well, I reviewed Evans following seeing it cited in the government.
So you never had a discussion post to that, or something you think is significant in terms of the outcome of your case?
I think it's significant insofar as it clarifies what the court, not just here but everywhere, has been saying for years and years and years, which is that criminal liability under Pinkerton and sentencing liability under our guidelines are two different standards. And the government wants to carve out some kind of exception for the aggravating role. And the defense, Mr. Bright, myself, dispute that there should be a carve out there. And I think Phelps pretty clearly tells the court that relevant conduct matters as to the number of participants and not just the role itself.
So is it your view that this conduct must be conduct that the defendant has been directly involved in, directly related to them?
My view would be that it must fall within the relevant conduct guideline of 1B1.3.
Do you understand my question? Is your view that the conduct must be conduct in which you are directly related?
Yes, Your Honor.
You cannot go outside of that. In other words, it's not broad in terms of the scope of it and deal with conduct that might be within the scope of the conspiracy with which she was not directly related. It cannot be that view.
Our assertion is that it should not and cannot go beyond what qualifies as my client's relevant conduct as to jointly undertake criminal
Do
activity.
you know of any case that says it must be conduct that must be directly relevant to what the defendant is involved in?
No.
So this is your first time being opposed to this.
Your Honor, I enjoy being, I hope I'm making a legitimate and non-frivolous argument, but certainly, Your Honor, I was struggling to find case law.
I think we dance around in terms of how we play in commentary and guidelines and what is it really got for in criminal activity and scope is what we're dealing with here. And while in terms of what a person is actually convicted of is one thing, but what you can be sentenced for under the guidelines can be broader. And there is some, in fact, it could be some ambiguity here, commentary, with some clarification on it, but I think it really comes down to, in terms of holding that we can hold here today, would be we hold such a thing that you've got this court judge, Davis got to enumerate what he was directly involved in. Only those things can be counted for purposes of sentencing. Is that your position? That's what I'm asking. That those things that those individuals he dealt with directly must be the ones with which they count for purposes of sentencing.
Our position is that the sentencing judge must go through the relevant conduct process as to the scope of the jointly undertaken criminal activity, that the judge makes the findings, what did the defendant do, and how many participants were involved in that.
So just I want to keep this. If the judge does it, can that include activity that for which that defendant was not directly involved?
Your Honor, if it was not a part of the in furtherance of the criminal activity or reasonably foreseeable in connection with the activity, then no, it should not be considered.
Yeah, I understand that. I'm not sure I do, because either as you articulate, there are individuals this defendant directly worked with and dealt with. I understand that's your belief, that's what you count, not this broader group of people who were part of the overall scheme of how things were done. Is that your argument?
Correct, Your Honor.
Has any court held such a thing for us?
I am unaware of, I'm certainly aware of cases that say that relevant conduct can be greater than offense, conviction offense.
Seems like all
conduct.
All of them say that. Isn't that true? It could be greater than this.
And I would argue that the same can be true going the other way as well. And right now, and perhaps that's what Evans helps us out with the most. And our argument would be that this should not just be one-way traffic, that The government gets all the benefit from the fact that it's not, the sentencing guidelines aren't just limited to offense of conviction conduct. But when it goes the other way, the government gets to say, oh, no, offense means just the entire conspiracy, and that's what was indicted, and that's that. It means that's how it exists.
End of the day, you're really just trying to get rid of only two deals and go back to resentencing. I suppose we did get 97, we get some of those. So,
Your Honor, every month matters to our defendants, to our clients. Thank you, Your Honor.
Thank you, Mr. Wallman. I know you were court appointed, and for the students, I want to explain what that means. Mr. Wallman, many other times by men, vetted by the court, either support the circuit court office, take on appointed or for criminal defendants who may not otherwise afford the retain private counsel that we engage part of our criminal justice system that could not operate. Our court will frankly the justice system at all without orders from the OPON to undertake this challenging work and to try to find out on behalf of Mr. Garfield's
Thank you, Your Honor.
and Ms. Niemeyer, thank you for your excellent advocacy on behalf of the United States. We're going to come down to the council, but before we do that, all right, we'll come down to the council, take a very brief recess here. At the same time, on for a second.
This is honorable report, we'll take a brief recess. But we've been able to turn this off a bit. Oh, yeah. Right, they're in communication. What they feel now. Yeah, well, I'll stand over. Right. Is that good for you? Check, but I don't.
Can I get one of you guys to speak into the mic for me? Either one.
Testing. Testing.
Oh, no.
Yeah, I was gonna lay it down.
Test, test.
Justice of the United States Court of Appeals for the Fourth Circuit.
Our second case is 23 versus Mitchell. Jones.
Chief Judge Diaz, Judge Wynn, Judge Thacker, may it please the court, Mark Jones for Christopher Mitchell. I wanted to take a moment before turning to the guidelines calculation issue and the Kaiser versus Stinson issue to briefly address the assumed error of harmlessness inquiry. First, it's the government's burden here to show with certainty that the district court would have imposed the same sentence absent the error. And I believe the government falls well short of doing so here. First, this is not a case where the district court made an explicit finding on the record that it would have imposed the same sentence. This district court judge knows how to do it. He makes these kinds of findings frequently. And this court has affirmed recently, in the last 5 years, a number of his cases under this doctrine where he made explicitly such a finding. So what we know is that the judge is aware.
Would the judge have needed to do that? Was the judge required to do that under our U.S. versus Dolphin John?
It's not a requirement, but it's incredibly difficult to find a case in which the court has applied the doctrine where the judge has not made such a specific finding. And I think the answer lies in.
Okay, so it's the court wasn't required to do so, but you're just saying, arguing that because the court usually does so, it should have done so here, even though we said it wasn't required to.
Right, it should have, but wanted to. It knew the importance of doing so, and having done so would have been a major signal to this court that that's how it felt about its sentence. Shivers, which is cited by the government on page 14 of their supplemental brief, I think provides the answers. And what Shivers says is that in a situation where the district judge gives a downward variant sentence that happens to land into the range that the defendant wanted originally, if that variance is based on factors such as the characteristics of the defendant, this court can't tell and can't know whether at resentencing the district court judge would have given another downward variance at that time. In particular, I point the court to footnote 4 of the Shivers case, which says
even though the government agreed to the downward, but maybe not to the extent that appellant wanted, but the government agreed to the downward variance.
they agreed to a downward variance based on some factors. We thought a downward variance based on other factors were appropriate. But what the Shivers court said, and
You're saying that even if, you know,
yes,
you're saying the government would have, if the government would have changed its mind somehow if we go back?
I guess I'm not particularly concerned with what the government wanted. This is about what the district court would have done if the guidelines were correctly calculated. And what it says, Shivers, is that the error is not harmless, even though Shivers received a sentence that fell within the guideline range that would have applied. The district court could again rely on the history and characteristics imposed below guideline sentence, and whether the district court determines to do so is in that judge's discretion. Because the judge will have that discretion, this court can't know with certainty whether or not that's what Judge Osteen will do. The government has to prove with certainty that's what would happen.
Right.
No, here we are.
Yeah.
It's up to the judge. He actually could get the same sentence, and that would be just, it went down quite a bit.
Yeah.
But you gotta get here first. You're not even harmless error. You gotta show this error.
Agreed. The best evidence, though, is that when we were back for a guidelines retroactivity question, he did give a lower sentence. Right.
You
So
understand what I'm saying?
I will.
Yeah.
And so as to the 1B 1.2D issue, that provision, the guidelines say that a conviction on a count charging a conspiracy to commit more than one offense shall be treated as if the defendant had been convicted on a separate count of conspiracy for each offense that the defendant conspired to commit. The government says, we just look at the indictment, it's perfectly clear that he was charged with conspiracy to commit more than one offense. Fine, I agree, but it doesn't answer the question, how many and which ones? And that's what the court has to know.
What about the language in the indictment that, I mean, it's the same time span. What about the language in the indictment that said, including, quote, among other locations within the Middle District of North Carolina and elsewhere?
I don't think that's,
Even though it doesn't specifically include, the exact locations that he was being held accountable for, it didn't be. It does say indictment among other locations within the Middle District of North Carolina and elsewhere.
sure, I think that's insufficient. I think it's too broad. And I think the court has to look at what's charged in order to determine what's charged by the counter charge of the conspiracy. And so when we look at the language of the conspiracy, even though it has that broad language, which includes not just the Middle District, but anywhere, in the United States where there's a used mobile metro CCS store, they actually identified were 4 locations affiliated with company B, 2 locations affiliated, 4 locations affiliated with company A, 2 locations associated with company B. But then the indictment subsequently charged 7 contract robberies, including the 6 that added up. The tricky part here is that everyone agrees that my client didn't conspire to rob all 6 of those stores specifically identified in the conspiracy. Everybody agrees that he didn't conspire to rob all 7 of the substantive account that identified stores. Everybody also agrees that those 2 company stores identified in the conspiracy account, and he didn't conspire to rob either one of those. The count, I think it should be at most the 1 robbery that identified in the conspiracy account. They are in the joint appendix, Your Honor, page 64. They are paragraphs 5, 7, and mobile, and of the reverse row. Here's the thing, nobody thought that you should not 6 moving or conspiracy account for all 6 of the specifically alleged robbery locations, just like nobody was coming in and taking issue again for all of the robbery locations. So the question is,
the factual basis of the PSR includes the robbery vouchers.
so there was no factual basis in the case, and that's really one of the problems we have, right? The factual statement certainly does describe those robberies and other robberies.
Yeah, that's what I'm talking about, the PSR, the factual statement in the PSR. It does describe those.
It does.
As part of the offense.
It does, because it calls them groupable offenses. That was the objection. We didn't think they should have been part of the offense conduct because they weren't charged in the conspiracy count. There was no factual basis, and
What would be the basis for holding that way? Is it a notice problem? Is that the argument?
it's a notice and it's a commentary problem. And even if the commentary doesn't apply because the court determines there's no ambiguity here, we have to look at.
We get to the commentary because
So
lines ambiguous or not?
I have 2 different arguments for that. The first is that, as I said,
Are they consistent with each other? Your 2 different arguments?
no.
Okay. All right.
So the first is that Moses.
One is Moses and one is the law.
Yeah.
Have you read Bowler, the
Yes.
Bowler opinion? Okay, maybe you could address that because that's precedent in our court.
Yes, I think the intra-circuit split on whether it's Stinson or whether it's Kaiser is still yet to play out. I know the petition for rehearing.
But Kaiser and Stinson don't have to be really in conflict with each other.
They don't. In a lot of cases, they're not, and they weren't in Campbell. But this may be the case that Judge Niemeyer was talking about, where it actually makes a difference with which methodology you apply on the front end, because this is a situation where the application note 4 tells you how to apply 1B1.2D. 1B1.2D says what we do once we know which offenses he conspired to commit, but it doesn't tell us how we determine. And one of the reasons, a pitch for Stinson and a pitch for Moses, and I recognize the panel, but 1B1.7 is a guideline. It went through.
Well, I mean, and it's the court.
That's
It's
right.
not just the panel, it's the law of the Fourth Circuit. But
I
go
don't
ahead.
know what to
The
do.
president of the Fourth
I
Circuit.
don't know what to do with Moses.
I understand what, right. I understand why you don't know what to do with Moses.
One answer to that would be Moses to come after the Spence.
It came before Bowler, it came after Campbell, and I've read everyone that had an opinion to say about the denial of petition for rehearing, and I appreciate all of it. But this is a case where
In terms of precedent, for with first one to start.
that is
the case law that says otherwise?
That is, I think the question in the petition for rehearing was whether or not Moses and Campbell were in direct conflict.
The petition said they're not. And so that was even in the
Right.
petition. Then you turn to what the rules are. Rules are very clear. And you look there, we don't have rules that are consistent in dealing with that. But yeah, you'll find certain splits all over, different certain splits all over the place. But we look to the first one. You don't like it, you either go unbound or you go to the Supreme Court. Don't do that. You have a case that is on board.
And it may well be, Your Honor, that Moses is wrongly decided as an outlier.
Really, Bowler is the most recent statement from our court on when Kaiser applies, and it's after Moses and Campbell. But could I go back to the question Chief Judge Young asked about knowing, and how could do you have an argument that the plea itself was not knowing? Then okay.
No, the standard of proof for sufficiency of the charge is different than what you get to put in under the guidelines. And this relates back to the argument before. Sometimes the
So
conduct
what's your notice argument then?
that
Lack of notice.
sure that if they wanted to use robberies other than the ones, they should have put them in the conspiracy. They should have identified the stores that they believed he robbed, and they said he engaged in a conspiracy to rob the following stores. Instead, they listed a whole bunch of stores and then tried
Right,
to
but
add
then that's why I would think that you might have an argument that the plea itself was not known because your client didn't have notice of the government's plan to include these additional.
But there are some that he did have knowledge of.
Okay,
And it's just one conspiracy. And he also pled to a substantive robbery. And so the additional ones don't change the statutory punishment range. It really is a guidelines question. And it's a particular question because it's a grouping guidelines offense. And the reason why it matters which ones and how many is that a grouping offense is different than, say, a controlled substance offense or a fraud offense where we simply aggregate all the harm. To properly calculate the guideline range, you have to know the specific robberies that occurred. And what the commentary does that's useful is it says there's going to be rare cases where we don't know how many. Application note 3 says when the conviction establishes 3, treat it as 3 conspiracy counts, 1 for each. But application note 4 says there are these rare cases where the plea agreement, the colloquy, we don't know exactly which offense, which robberies are part of this conspiracy. And so in that case, how do we determine? 2 things. 1, it had to be alleged in the conspiracy count, and 2, then found by the district court judge by this type of standard. My argument hangs on the first part of application note 4. It has to have been alleged in the conspiracy. And that's why I detail what was alleged versus what wasn't alleged. And even if we didn't follow the commentary on that, which isn't interpreting the ambiguity, but it's doing what 1B1.7 says and explaining how to apply it, it makes sense because 1B 1.2G is talking about a conviction on a count charging a conspiracy. So we should be looking at the language of that conspiracy count to determine what was charged there.
How do you respond to the present sergeant? The second rule was that it can't be right because that the second part of the application, you know, can be just referred to. You have to worry about this. There's sitting in the car, fact finding proof beyond reasonable doubt because you're all alleged to the account, and you need to apply the second part of that. So that, what about?
So just as Judge Osteen found, I think this case is Exhibit A in response. There are cases where not all of the substantive robberies are set forth either in the conspiracy count or in another substantive count. What was different about Robles and I believe the Ford case was that for each offense that the probation office wanted to use as a grouping offense, they were somewhere in that indictment. Perhaps they weren't in the conspiracy count, and that's why I think Robles was wrongly decided. But they were somewhere in the indictment, and that's why the court there said there's not a notice problem. The challenge we have, Judge Diaz, is that the two of these robberies aren't anywhere in this indictment. And that's the notice problem that is different from Robles and different from the Ford case. I do think that.
So I think what happened in this case was there was no actual nexus early on, but later on in the sentence, we chose to essentially accept that the PSR factual basis thing. You know, right?
I think I don't recall if he adopted the factual basis or we simply agreed that there was a factual basis to support.
If there had been a factual basis that included something that included the full robbery offenses that are concerned with it, would that have solved the problem?
I believe so. I do. I believe it would have solved the problem and we would have been out of the world. We would have been strictly in application note 3. And at least at the time when the judge was analyzing it, we would have been out of application note 4 altogether. And I believe that would have solved it. But this was one of those cases where, because of the way it was pled and because of how it proceeded, you could not look at this count and take his guilty plea and say which were the specific offenses so as to properly calculate the guidelines. And because of that, we believe the government was limited by the guidelines to what did it charge in the conspiracy count. And to simply say in any other A or B company, anywhere they may exist, was not sufficiently particular because you have to specifically legislate the guidelines.
All right, thank you. Lynn?
May it please the court, Stephen M. Ford, the United States. This court should affirm the district court in this case because the district court did exactly what section 1B, 1.2B called upon the district court to do. And as my friend, Mr. Jones across the aisle concedes, the defendant pled guilty to a conspiracy count in this case, and that conspiracy charged more than one offense. And given that, then it fell to the district court under the plain language of 1B, 1.2B to determine which offenses the defendant conspired to commit.
So what about the fact that two of the robberies that were considered at sentencing aren't anywhere mentioned in the indictment, at least not specifically mentioned?
Well, I would say, Your Honor, they are mentioned generally. And I think that obviously we talked about specific references to specific locations for Boost Mobile and Metro BCS in the general allegations of the first couple paragraphs of the indictment. And those are incorporated in the conspiracy count in the first paragraph of the conspiracy count. But then beyond that, the government alleges that those locations were among other locations in the Middle District and elsewhere. And to the extent that the court is concerned about, notice, I will say this, this defendant can be convicted at trial of conspiring to rob the Metro BCS store that's not listed specifically in the indictment and the Metro BCS store that's in Suffolk, South Carolina that's not listed specifically in the indictment, based on this court's prior precedent, the Supreme Court precedent, with regard to the specificity required in an allegation, in an indictment.
And what are those cases?
Well, Your Honor, the cases are, along the line, there is a, a very old case, but it's still good law, Cocker versus United States, 157 U.S. 286, Your Honor. That's an 1895 case from the Supreme Court. And that thread of what's discussed in there, Your Honor, follows all the way through to the present day. And it's captured in Rule 7 of the Federal Rules of Criminal Procedure with regard to what the government is required to charge in an indictment. And Rule 7 requires the government, Rule 7C, to provide a plain, concise, and definite statement of the essential facts with regard to the charge in the case. The facts that constitute the offense charge. This court has said, most recently, released a long time ago in the Pleading case, which is a 1981 case.
Are these cases that you're talking about, are they in your brief?
Your Honor, I don't believe that they are. I think that the notice pleading is something that undergirds all that the government does in terms of the indictments that it alleges. And so to the extent that the court is concerned about it, I could say that this is black letter law. This is not an issue that I think my colleague across the aisle is going to dispute. And I would say this, with
Well,
regard,
he doesn't have really a fair opportunity to dispute it right now, since these cases weren't in your brief, and it sounds like maybe you didn't provide them to them.
well, what I would say this, Your Honor, in terms of the notice in regards to this statute, if my friend across the aisle was truly surprised to see these Metro PCS stores show up in the pre-sentence report, I would have expected to see something along the lines of surprise. And if the court wants to see surprise with regard to what is this particular robbery doing in this particular case, the court can look no further than Joint Appendix pages 141 and 142, because in the draft PSR, which is found at Joint Appendix 118, the particular paragraphs there, paragraphs 30 through 35, the probation officer originally included a Circle K robbery that they tried to assess unit points to the defendant.
But it's not just surprising. Okay. Let me think. The position. How do you know when sentencing comes around? One thing, plea, and then sentencing comes around, the PSR takes down one and divides it into 3 different locations, 2 of which have been mentioned in the indictment. And perhaps more important in this case, which is curious to me, there's no factual basis that's presented at the time of the guilty plea for which the defendant concedes had it been, then would be okay with it. And yet, you know, the PSR comes out. So, I mean, it comes down to, I don't want you to go to the word limiting principle, but that's kind of what it sounds like to me. That what is, how do you know? I mean, you charge a robbery at company A, and that's it. And he gets a plea to company A, that's it. Nobody puts a factual basis that you got a date and time up there that can tie you into, I guess, Greensboro or something like that. But you don't have date and time as to Annapolis and Sumter one there. Yet the PSR shows up and it's additional. I have no doubt you know this. But that's not the question. The question is in terms of how it's presented procedurally. You know, at that time, why is it usual not to do a factual basis at the time of the plea?
Sometimes we do, Your Honor. Sometimes in cases with this many conspirators, we don't always file a factual basis because sometimes some of those conspirators might wind up cooperating with the government. And we want to be able to talk to them about the allegations we've made in our indictment to determine.
Well, that's a choice you make, and that choice is sound, but if you make that choice, you can lose certain opportunities in case when you don't do that. You know, we're talking to some of the students about being military, and I look at something like this, and every time I see something like this, I said, this would never happen to us. Because the problem is you believe to go through every last thing you did. You would go through every location before it could be accepted. Yet, you know, in the federal system, we don't do that. We take these federal pleas. But it seems to be somewhat problematic in a case like this, where at the time of the guilty plea, it's a knowing plea. There's almost an argument here to set aside the plea, but I'm pretty sure that would give it value to the defendant. If you set aside the plea, go back and say, okay, we'll start over. then you're gonna bring a factual basis in. There's nothing here, so that can lead nowhere. Really, it's the basis of the plea. That's really what's going on here. And now we have sentencing on it and using different locations, not mentioned in the indictment, no factual basis for it, pops up in the PSR. And yet, there is a Bruns interpretation of the case law. So notice goes more than just surprise and fairness when we're dealing with the process.
Your Honor, my response to that would be one, to say that the court did find a factual basis before starting this sentencing hearing. At the very outset, the court confirmed at Joint Appendix page
Just after
46.
after he had made the plea, all I'm saying is, how do you know the plea is knowing? If you do it after, sure, you go after and say, okay, here's the factual basis and all of it's here. Maybe you can say you didn't object. That might be the thing.
And I would say that, Your Honor, because I think at this point, it's incumbent upon the defendant then to say, before the court accepts this plea, before it takes the factual basis at the sentencing, because it is not a judge the defendant guilty by that point, it's incumbent upon the defendant to say, hey, wait a second, we didn't know that we were conspiring to rob these others.
When this thing was entered the plea, you had an idea that the PSR was going to pop up for 3 different locations and therefore the end of it.
Well, Your Honor, I think not only did the government have an idea, the defendant did. And here's why.
Well,
This is
I'm
what's not.
because I'm thinking that you're into it. I'm not saying you should. That's it, but I'm just thinking when you start out, parties there, other than you go to say company A, company B, you got specific dates that's each, but then when sentencing comes up, you pop in 2 other places there. My question is, was that in your mind or his mind? I mean, it could be. I'm not saying it can't, but it just seems like it's not the kind of thing you might have been thinking. Certainly, I would think a defendant would be thinking in that level until it kind of pops up. Maybe they do.
Your Honor, one thing again, that the court won't find in this record anywhere is the notion that the defendant was surprised about these other 2 robberies. And the reason for that is because the government provided discovery. So the same discovery that the government provided to the probation
Well, I
office.
don't think it's surprised. This question is, was he surprised by the use of it? I mean, yeah, you believe one thing, it's company A, company B, that's all you got. Which, when you think about it, is okay, all these robberies is company A, all these company B. But then you get the PSR, you separate 3 different robberies, because those 3 different things have been planted here. Now, I don't think it's surprising that these happen. The surprise is they're being used as 3 instead of 1.
Well, they're locations, Your Honor, if there's no one locations of Metro PCS.
Again,
And that's
same
what
company, fled to the company. And the company is what pleads to. Doesn't matter what the company can look at. I mean, a conglomerate company and it can be located in 10 different countries. I mean, you don't have 10 different charts, but these were specific things. These individual robberies occurring. I understand that, but I'm just saying, in terms of the way these cases are handled, it seems to me, first of all, pure. Seems to be simple pure with me. Just give the actual basis. Time of believe. The phone is already indicated. You would indicate that.
Life certainly could have been easier, Your Honor, if we I won't deny that. I will tell the court something else that I think is significant. We haven't gotten to the application note. I'm not suggesting that the court needs to get to the application note, but the district court, in this case, very experienced district judge, very careful district judge, asks not only the defense counsel, but the defendant himself at the very outset of the sentencing in this case, is there any notion that the government doesn't have proof beyond a reasonable doubt that your client committed all 4 of these robberies? And my friend across the aisle says no. And then the court doesn't have to, but the court does. Looks at the defendant point blank. It says at Joint Appendix page 45 and 46, as I understand it, you don't object to the facts. And specifically, you don't object to my finding that if I'm called upon to do so, that the government can prove beyond a reasonable doubt your participation in the commission of 4 robberies of the wireless schools. Is that correct? And the defendant unequivocally, straightforward says, correct, sir. So there's no dispute that there's proof beyond any reasonable doubt that the defendant participated in these 4 robberies.
Second half of the first argument is the guideline itself is ambiguous, but Mr. Jones points out that's just part 2 of the 4, the other part being the defense has to be specifically alleged to either conspiracy, if you do that without any confidence, that's not an unreasonable reason of that application. So why is he wrong?
Well, I think he's wrong about that, Your Honor, because again, what we have to allege in a conspiracy count, to put the defendant on notice, is a plain, concise, definite statement of the essential facts constituting the offense. And the essential facts for a Hobbs Act conspiracy, merely a knowing agreement between two or more persons to interfere with commerce by robbery. That's what's alleged here. And so there is a knowing agreement alleged among these 9 individuals.
So the application talks about an object offense, right? So that seems to suggest a specific offense, not just a general description of the conspiracy.
Well, I think there is specificity here, Your Honor. So if the court looks at the date, we've got August 16th to September 15th, 2020. So it's already narrowed very far in scope. And then it discusses not writ large robberies, commerce writ large. It's talking about 2 corporations and their franchises and locations. Company A and Company B, Boost Mobile, and Metro PCS. And then it's talking about, furthermore, that the conspiracy, the objects of the conspiracy were to unlawfully agree to take and obtain property, including the United States currency and wireless devices, from employees of Company A and Company B. That's squarely in the plain language, plain text of the conspiracy count. And so right there, the defendant's on notice that the defendant is going to try, the government's going to try to prove that he conspired to take money and cell phones by force from employees of Company A and Company B, plural employees, not one employee from Company A and one employee from Company B. And to boost the argument even better, there are 7 locations that are listed in the indictment. Beyond that, again, getting back to this notion of notice pleading under Rule 7, if the defendant wants to know more, with more specificity, which places exactly do you think I've robbed? Which places do you think exactly that I've expired? There is a mechanism under Rule 7F that this court has said that the defendant can avail himself. He can move for a bill of particulars and say exactly which locations do you say that I've conspired to rob. And the government.
So in your view, the government did not even need to list any specific locations in the indictment for notice pleading to be sufficient because it had the date range, the companies, and then also locations within the Middle District and elsewhere. Middle District, North Carolina, and elsewhere. That would have been sufficient without naming the locations. And then if the government, the defendant wanted locations, they would have asked for it.
I think it would have been sufficient, Your Honor.
Right.
And, again, he's not without the ability to challenge that. He can make a motion under Rule 12 and say, hey, listen, I have no idea what's going on here. I don't think you stated the defense. Or he can go one better and look at Rule 7F and say, we're going to
or look at the discovery.
Or look at the discovery. And in the discovery, he's going to see, Your Honor, because, again, the same discovery that the probation officer had and produced the PSR from is the discovery that the defendant was provided.
Let me ask you questions. Here's about everybody's about police. So, but if you have an indictment that says for count 1, that does give a specific date and time, and at court, the evidence shows guilt at one of the 3 places, but not the other 2. Or put it this way, would the jury be required to determine guilt as to robbery of all 3 places, or could it just pick one? And how do you know it would have picked a particular one without the particularization of the location?
Is Your Honor asking with regards to whether the conspiracy count would then be viable if the jury only found one location? Your Honor, that is in fact the case. And I will tell the court that.
But before we go there, I don't want to get into the point I'm making here is the abuses for purposes of sentencing, that we conclude that there's reasonable doubt on all 3 locations, that a jury wouldn't have to find guilt on all 3 locations. He could do it on 1 or 2. Is that correct?
It could, Your Honor. It could find.
So how do you conclude at the end that the trial fact there's a reasonable doubt basis and support for all three.
Because
If
that's,
they didn't need it for an indictment purposes, or for a trial purposes.
because that's what the district court is charged to do, Your Honor, in the 1B 1.2D. And so if I can, probably provide an example in another context. So suppose somebody out here on Fayetteville Street goes and sells 3 grams of fentanyl today, and the government charges him with distribution of fentanyl on September the 10th, 2024, and he pleads guilty to it. Defendant might think my exposure is limited to those 3 grams of fentanyl I've sold, but under the relevant conduct rules and guidelines, if he sold 3 grams of fentanyl to the same individual every day for the last year, the probation officer is going to assess his relevant conduct, and his guidelines range is going to be something attributable more like 1,000 grams of fentanyl rather than 3. That's simply the way the guidelines are set up. And it doesn't necessarily mean that anybody has to agree with them. It just means that that's the system that we have. And so in this system, under 1B 1.2D, it's the district court that's tasked with determining which offenses did this defendant commit as part of this
Could
conspiracy.
you also speak to the harmless error?
Your Honor, I think with regard to harmless error, I would agree with my friend across the aisle. It is certainly an uphill battle for the government, and it is one that has to be clear from the record. But I would say this, as the court can see at the end of the section here in this case, Joint Appendix 92, the court says, I really was not going to vary in this case. In other words, the court was going to be stuck at 120 months. And the court only went down because the government came in and said, Your Honor, we think variance is appropriate. I didn't think before I went into this case that a variance was appropriate, but we think 108 months is the right number. And the court did give 108 months. When this case came back before the court for resentencing on a 3582 reduction, the court gave the defendant 100 months. So it went down because his criminal history points had gone down. And the court looked at that, considered his post-defense conduct, considered the danger to the community that would be presented if he were to be released early, and went to 100 months. I will tell the court that 100 months is exactly within the range that the defendant is requesting now. If he prevails, he's still going to be in 84 to 105 months. And the court gave him 100 months at the 3582 sentencing. So I'm saying if there's an error, it is harmless, because the judge is still going to wind up with that 100 months.
I thought in the beginning you said that that would be a hard argument for the government to make because the sentencing court said I was not going to vary.
It is. I will say that there is some sense of reading tea leaves and trying to figure out what the district court would do if there's error here. But again,
So if there is error here, is the government's position that it is harmless or not harmless?
the government's position is that it is harmless. That the sentence is still appropriately 100 months because that's the guideline range that the defendant would wind up with if he were to be here. But the government would like the court, of course, to find that there is no error.
This court's going to give the Senate bill.
I don't believe so, Your Honor, given the record.
You gotta say another way to do it, don't be honest. There's a chance he can get it going, don't you think, that even the defendant would like to have the opportunity to go more? But you saying, oh, this is, he won't do. Well, what Judge Osteen would do, but it's reasonable judge. Even to have gone here, he went out of his way to make it, he wouldn't have it, it's from the history, the other things here, that's the reason for it now. It was 108.
It was 108, Your Honor.
And now it's what?
Now, if the defendant were to prevail, it would be 84 to 105 months. So, right now where it stands is 100 to 125 with the reduction in the criminal history points that the Sentencing Commission made retroactive. But again, we would ask this court not to find that the district court here, because the district court conscientiously found that the defendant participated in 4 robberies, and that's what to affirm the district court on that basis. Thank you very much.
Thank you, Your Honor. Just briefly as to the assumed error harmlessness, it's not about the range. We don't ask, is he now in the range? It's the specific sentence. Would the judge have done the same thing? And if the government hasn't proved with certainty that it would have done the exact same sentence, then it it doesn't win on that, and this needs to go back for a resentencing. A couple points. We're not challenging the specificity of the indictment. But what is required under notice pleading under Rule 7 is different sometimes than what needs to be pled in account to get certain enhancements or adjustments under Chapter 3 grouping to
So
apply.
you're just saying that the plea is not proper, because the defendant was not given proper notice, he doesn't know when to plead.
No, Your Honor, I'm not challenging that at all. That's my point.
That's what I'm getting to, just that if we set aside, go back and start on over.
Not only did he plead to conspiracy, he pled to one of the substantive counts. Right, and so there's not a doubt that he knew, at least for that count and to what was alleged in the conspiracy count, what some of the offenses were. But there are cases where the guidelines say you need to look at what's actually charged because it's the offense of conviction, not just relevant conduct. I know this happens in the gun guidelines. You look at the offense of conviction to determine how you can count points. That's what makes this different than the analogy about somebody selling drugs, 2D 1.1, because that's a non-grouping offense. The guideline treats that conspiracy differently than it treats the conspiracy charged in this case. This is a groupable offense conspiracy. And so you have to know how many, and you have to know specifically which one, because for each one, you have to go through and calculate a specific offense level. You have to look at specific offense characteristics to know how many units to give under grouping. That's why it's important that the defendant have, knowledge of what these are. But that's also why the application note talks about the count charging the
But then
conspiracy.
why would the defendant plead guilty with no factual basis, knowing that?
Well, he certainly knew that he committed the substantive robbery charged in count 2, to which he also pled guilty to, and that was sufficient to make him guilty for a conspiracy. Right? And that's all that a jury ever would have needed. As Judge Wynn's question, let's say you had an indictment that alleged 10 different robberies. All they need to believe is one. I believe they have to be unanimous as to that one. And I think it would be a smart thing to give a special verdict asking for unanimity on that object. But there wasn't a doubt here about whether he was guilty of count 1.
Absolutely. The factual basis time you plead, ultimately came out PSR. Could the defendant have withdrawn his plea at that time or moved for it?
No, sure, of course, yes, he could have, but he wouldn't have, because he was guilty of count 1 and count 2.
And he acknowledged the factual basis that was there, which included provocation, that right? Didn't it?
That's correct. This is not
So with that one, there's no objection. You got the factual basis. He's not yet, just not yet, except plea. Good. It seems like to me, if you don't like it, you say, no, I didn't do something. No, that's not me. So those things happen to some other people. You can say, I want to withdraw my plea.
right. So this is not a fight about whether or not he's guilty to count 1 or count 2. It's about how the guidelines get applied. And when you look at the specific guidelines that are applicable to conspiracy for grouping offenses, and you apply the application notes, it says that there are 2 requirements that the government has to go through. First, it must have charged it in the conspiracy count.
If you don't apply it, I get some commentary. You say it's unambiguous in terms of guidelines.
I don't think so. And I admit this is a more challenging argument. So the court would then be left without the guidance of application note 4 to determine which specific ones did he are in this count. And so I think the court would want to do the same analysis, just like the guidelines say, look at what's charged. I think this court, in creating its own standard on how to determine it, would look at the count. And I think the court then should also say, just saying A and B is not good enough, because there are so many A's and so many B's. And it's, yes, there's a time range, but it's any A and B anywhere essentially in the world. And there are literally thousands of these. And one of the ones they included here isn't even in the Middle District. It's not even in North Carolina. It's an entirely different state.
Well, that's the or elsewhere in the indictment.
That's right. And so my argument, even if the court didn't have the benefit of the application notes, I think the court would say it's not sufficiently alleged in this count 1 conspiracy for the grouping rules to apply under subsection 3T.
Thank you very much.
Thank you, Your Honor.
Mr. Jones, I know you were court appointed. We're grateful for your fine advocacy. For your excellent argument on behalf of the United States. We'll come back down and please counsel. Move on to our final case. All right, I've heard in final case this morning, 2073, John Doe 2 versus David.
Your Honor, Mr. Davey, on that too. Rob Murphy abused numerous male student athletes under the guise of providing them. Many, including John Doe, after main school head coaches warned the senior associate athletic director that Murphy was engaging in sexual grooming. After this grave breach of trust, NC State asked the store to hold that such a warning was not enough to put it on notice of an obvious risk, that it needed specific knowledge of the specific act of police complaint. Because that's not the law, and because it shouldn't be the law, this version reversed. The district court dismissed on the basis of actual notice. Colleagues also have arguments about the appropriate person prong. I'm not start either of them, although I'll start with actual notice. The actual notice here, I think, is quite clear. When a coach says that a trainer is engaging in sexual grooming of male athletes, engaging in the present tense, gerund form of the verb, athletes plural, that's very explicit. That puts the school, when it's made to an appropriate person, puts the school on actual notice of.
I think I read opposing counsel's argument to be that sexual grooming somehow does not equate to sexual harassment under Title IX.
Yeah.
What's your response to that?
I have two responses to that. The first is that I think that it is. We can talk about that. And the second is that.
Well, let's talk about that then.
Sure.
Let's start with this.
Sure.
I think that it is. I want to know why
Sure.
you think that it is.
Yeah, I think that it is because if you look at what we cited the sort of the definition from a notable outside advocacy group and also this court's decision angle about what grooming is, and even here modified by sexual, right? Predatory, it means preparing someone for coerced sexual conduct. And it's, especially again, when it's modified bisexual, it reflects that Finley, the coach, was making the report, regarded it as predatory, preparing athletes for abuse. Use of sexual grooming can be more obvious than listing illicit grooming behaviors. Like the conclusion has already been drawn about exactly what it is and what it's doing. And so I think it is sex-based discrimination. That's the first answer. The second answer, though, is that I actually don't think that it needs to be on its own a Title IX violation itself. What matters at bottom is whether it's providing notice to the school of what the obvious risk is, right? And that's the Kuhn formulation, as this court discussed there. If it must have put, it's not constructive, right? But if it must have put a reasonable person on notice of the risk going forward, that's enough evidence. And so, again, Judge Thacker, I agree with you that it is itself, it is itself sexual abuse, right? But if it's actually not important whether it is without.
Does it matter what the fact that we're at the 12-6 day, so probably about 6 weeks long, it might well be that some isolation might be considered to be relatively would not be but some of which obviously are much more so, and so which would be then just considered in the light most favorable to you and say that that's plausible that includes this whole range of conduct, some of which clearly is correct.
Yeah, I think that's right, Your Honor. And I think that, one of the things that's, I think especially hard here is that it is a motion to dismiss instead of at summary judgment. Actual notice itself, this court has talked about it in Kuhn, this court has talked about it in Fairfax. Obviously, it matters exactly what that report is communicating, right? But I think at this stage where there hasn't been, you don't have the senior associate athletic director having testified to what you understood it to be or what the coach, whatever, the inference, I think, has to be that it's the most serious possible version. Again, especially when it's modified by the sexual. I think the inference has to be the fair inference in the non-moving party's favor at this stage has to be the most serious possible version of it. And again, when it's modified by sexual, I think that makes it, frankly, an easier question too. It's not just these engaging in grooming; it was engaging in sexual grooming, which I think makes it harder to say that it's sort of an inference about that innocuous, inappropriate comments like liking social media pictures. I think that's right. Again, so I think engaging in sexual grooming is sex-based discrimination, but it doesn't have to be the stolen days. I think that the school's proposed rule, I think is a problem, right? No one wants to sort of live in a world where a school gets a report like this and has no responsibility to do anything unless a trainer like that have ongoing access to student athletes. But the senior associate athletic director knows are being groomed or at risk of ongoing sexual abuse. I think that's just a problematic rule.
There's probably on the outside of the system, our president seems to require more that we're talking about sexual harassment, which is not maybe an isolated incident, it has to be sufficiently pervasive and extensive to not to an environment with harassing contact. So what's and that sexual grooming, the term sexual grooming in isolation just doesn't work.
I think that I think I have a couple answers to that. One of them is that specifically the allegation of engaging in sexual grooming of male athletes, plural, right? And so I think that on its own is enough to sort of denote that there's an environmental problem, right? But the second is that the sexual grooming itself, again, when you think about what's going on, right, which is a trainer who has access to a lot of athletes, especially who are receiving medical treatment in often very vulnerable conditions. I think that is just exactly the kind of serious thing that, it is enough. It's severe. It's possibly pervasive because of the number of athletes involved. And I think if you look at what actually happens, probably, yes, sorry. I would say certainly, right? And I think that, again, when the inference is not even an inference, right? There are numerous athletes that have subsequently come out and said, there are at least 3, cases that were filed. this was not an isolated incident. I think it's fair. I think it's a very fair inference in context that this was, even if you take the school's position at face value, I think this is important, especially for
So I think it's business, but for me anyway, the more problematic aspect of this case, you want to for never wrestling with, because it would seem that the makes
yes,
are in for reporting purposes. And I'm concerned that, first of all, I don't think the complaint alleges that. Correct me if I'm wrong.
Yeah.
So other than the title, so what is it about the allegations of this that are inferring that this individual was the person?
yeah, I think I agree with you. I mean, first of all, the district court didn't sort of assumed it is not to decide on that basis, but again, I think it's important to talk about. I think that Clingsdale is an appropriate person because based on his, again, as you know, his title and his role in the athletic department, he had authority to take corrective measures. However,
Okay, so why is it? Why do you say?
I mean, I think there's cases like, Grabowski, Morrell, Kesterson, and other circuits to talk about it. Need not be an apex figure, the senior associate athletic director is extremely high up in the athletic department structure. But however, that I was going to say though, that however, the more important difference here, I think, to be drawn from the complaint, is the complaint talks about after the report, Murphy had his duties adjusted to reduce, although obviously not eliminate, his access to male athletes, and that's an allegation in the complaint.
But that wasn't immediately after the report, right? That was
No.
like a year and a half after the report. So
Something-
why isn't that too tenuous to make the connection that you want to make?
So the reason that the delay does not matter, first of all, that's an inference that would be drawn against us at the pleading stage, right? And we cited the Federal Register, college bureaucracy, the notions of due process in the course of how schools deal with all of this stuff. And so talking about if this comes down to plausible inferences to be drawn about the delay, that has to be drawn in our favor. It doesn't matter actually if there's a more plausible inference. It only matters that our inference that we're asking for is plausible.
Well, at which point does an inference become speculation? Speculation.
No, I agree with that. And I think that, again, when the complaint specifically says that his duties were reassigned to reduce his access to male student athletes, I just think that's, I think that's enough. And I think it has to.
That's in 2017, given this, when you say your inference, you corrected that he was reassigned in 2017. Well, then he was promoted in 2018.
Yeah.
That might seem to cut against the fact that at least the question about the inference that he was reduced to even from athletes. Then you turn around right after the next year and just promote.
Again, I think it's amenable to several inferences, and the inferences have to be drawn in our favor, right? If between the having his duties reassigned and the promotion, it's intended to keep him behind his desk and reduce his access to athletes, I think that's enough. And whether it comes out, this is the kind of thing that discovery is for, right? If there's multiple plausible competing inferences, I think that's enough.
But there are competing allegations in your complaint. You want us to make the causal connection about Murphy's reassignment, but then you also allege that Clingsdale either disregarded Finley's report or concealed it from the athletic director or the Title IX coordinator. Both those are inconsistent.
Yeah, I think that I think part of the problem here, the complaint also talks about how there is this report that exists that one of the other students who is a plaintiff in the companion case that's both still live at the district court and also consolidated at this point in front of this court. It talks about how there is this report that exists. It talks about all of this. John Doe and could only allege in the complaint the things that he knew, and I think that there's multiple. I think that a fair reading the complaint, including the allegation that you noted, is that a report was made to the senior associate athletic director. Senior associate athletic director adjusted the duties. Whether he told some, I think there's two possibilities here. Either he just adjusted the duties on his own, which is enough. That means he had authority to take corrective measures, which is what the standard is. Or that allegation, he actually did tell them
who did have authority to undertake corrective measures, and that person did. And so I think that the key inference here is based on the adjustment or reassignment of movements duties. I think that's it.
How does that square with the notion that the diversity is deliberately different with some?
So this court's decision in SB and numerous circuits, the First Circuit in Paul, there's other circuits that say, it's not just that you have to take some action. If you take an action that is entirely ineffective, that's not enough. And I think that here, where you're still allowed to have access to at least some athletes, including entire teams, including John Doe's team, it's certainly deliberately indifferent. It is plausibly alleged at this posture deliberate indifference to at least as to those athletes. And I would note
Inside the reassignment issue, how is it against that the allegations of the complaint support that things are sufficiently senior to take corrective action?
again, I think the inference based on both his title and the allegation that corrective action was
Wait,
taken.
take out the corrective action.
Yeah.
So it's just his title?
Well, and the fact, he received the report. He has a very senior position, corrective action.
In fact, his title is senior.
Yeah. Yeah, and
Right there in the title.
and corrective action was taken. So I think it's fair. Like the allegation is that there was a fit between exactly the report that was made and the readjustment duties. And so I think that's, I just think that's an obvious instance to draw. I think in that circumstance. And again, just to come back to sort of this question of, yeah, I think that's a fair, instance to draw. I guess I'm also, there's a fourth case from not this circuit, but different circuit, that the fit of a remedy in the stated problem itself it supports an inference like that. And I think that case was, where there's a risk to male athletes, an allegation that they reduced access to male athletes, including entire teams, and gave them more testimony. I just think that's it's called Ford.
What's it? They consider your old chair more about the big state of Pleading perspective.
Yeah.
Of course, the district court thinks.
Yeah.
So would it be appropriate then to see the sent back and that's allowed for further?
Yeah. I think that's yes, Judge, I think that's correct. And I think one of the other things that's a little complicated here is that, as you'll notice, the district court entered the order. There was no amended first complaint. Enters the opinion, enters judgment on the same day, and it's silent as to whether or not it's with or without prejudice. But entered judgment and closed it, directed the clerk to close the case. I think that if what is going on here is that this court has some concerns about the sufficiency of the pleading, I think you're exactly right. The right answer would be to remand with instructions for to allow the complaint to identify or to correct the deficiencies in the complaint, because at the very least, what's going on here is that you're not looking at a complaint where it's futile to amend, and it would still be able to state a claim based on what they're, even if again have some questions on the complaint as is.
We're done in temporal issue. Robert saying reckless and Robert, let's just land. Okay.
I don't think it does, and I think there's a couple of reasons for that. One of them is that in that case, the person who was alleged to have later had done the firing, and retaliated. The point of that case is that person never had knowledge, right? And so I think that that case is, and we wrote about this in the brief. I think it's just distinguishable for that reason. And again, I think there's a separate problem here, and we talked about this in the brief too, is that college bureaucracies are different than sort of fast moving businesses, like kind of issue case. This court has obviously seen, other kinds of suits in the college context where due process has not been allowed to play out appropriately, and so I think here it's a longer delay or duration. I think it's much more understandable than that involving private business.
All right, thank you very much.
Yeah, I'll see you on the call. Thank you.
No.
Good morning, Your Honors. Chief Judge Diaz, Judge Wilson, Judge Scott, and Dixie Wallace here on behalf of the state. Neither NC State nor its leadership condones sexual misconduct of any type. We're here today on a legal issue, whether the plaintiff has stated a claim under Title IX. The district court correctly concluded that the comment about suspected is something that you did not hear in the Title IX. That suspected brain, not just sexual abuse. That does not provide the actual notice of sexual harassment that is required by the Supreme Court to state a claim under Title IX that no sort of dates. I'd like to begin by addressing a question that Your Honor raised about amending the pleading in this case. In this case, this is Doe 2. It was the third case filed in a series of cases. The first case, Locke, was filed 6 to 8 months before Doe 2. The motion to dismiss in Locke was fully briefed before this complaint was ever filed. The plaintiff had the benefit of those arguments and could then craft that complaint to be the best it could be based on those arguments. There was a second chance to amend after we filed the motion to dismiss in the district court. Again, plaintiff did not choose to amend at that point. They could have amended as right. Instead, went through the briefing. Third, the court this court will look at the order entered by the district judge court that's at Joint Appendix 37. The court dismissed this without prejudice. The court did direct the clerk to go ahead and close the file, but this court, in its Britt versus Joy case, sets out what happens when a court dismisses without prejudice, but does not explicitly invite you.
Yes, this question makes it in terms of going back with specific to the authority, the appropriate authority. The district court did not address that at all. In fact, it looks like everybody just assumed so. It is probably some level of concern. The court then send it back. Would it not be appropriate for the district court in the first instance to address the question of whether the appropriate authority?
No, Your Honor, because that issue was thoroughly briefed at the district court. Yes, you're exactly correct. The district judge did not address that issue and decided it because this could be decided on appropriate authority, or it could be decided on actual notice, and the district court opted to decide purely.
That's 12B6. Young. And the question comes up, and the answer would be and assume the individual you addressing something less than low level. And then you even have some action for which at least in plaintiffs alleged there can be an inference. When you have someone after allegations who then reduced in terms of their responsibility to not be around athletes, that at least gives you the inference that this person could take corrective action, which is sort of the appropriate authority. In other words, can you do something? And it looks like at least Kingsbury was in a position that he could do something by inference because with 12B6, I think that 12B6 is key here. If you look at other cases of that inference, inferences that can be made from it.
Your Honor, Gebser and Jennings are very clear that the official must have authority to address discrimination and to institute corrective measures. They make very clear that's part of the common facie case.
We all agree on that. That's the point. They make that clear. Of course, not really clear here is when we get up and look at the inferences here. Those inferences challenging that. That's the question. And is it conclusive in a way such that we can say, well, 12 and 6 apply?
No, Your Honor, we can't make that. The court, the 10th Circuit in Europe, says that a title does not define what someone's authority is. Each institution has different titles. We don't know how many senior people there are in this department. We don't know what authority that person has. the complaint, we are bound by the four corners of the complaint, and there are no factual allegations regarding Clink Scales other than his title.
Isn't that the problem? We don't know.
Well, yes, Your Honor, but that's the plaintiff's obligation. As the district court said in the Moss versus Penn State case, it's not a daunting task to include those facts, but plaintiff did not include those, even though plaintiff had multiple opportunities to draft this complaint and to amend after the complaint was drafted.
Of course, that means we cannot make an inference. There's no reasonable inference that can be made. Not that he said it specifically. Inference. 12 and 6 problems. They need to be addressed.
No, Your Honor, this court can't. Under Iqbal, we can make possible, we have to cross the line between possible inferences and plausible inferences. It's a possible inference, but there's nothing in the complaint, in the four corners of the complaint, to raise that from a possible inference to a plausible inference, or using the language from Kuhn, a reasonably plausible inference. That's just not.
It does allege these claims that he is the proprietor. They say that may be good for which is alleged, but does it not?
No, Your Honor, it doesn't. It says nothing about what sort of authority Clink Scales had. It gives only his title. Plaintiff says, well, we can conclude actual notice because the job duties were changed. But Your Honor, that was an 18-month period between the time that the allegation, that the report was made to Clink Scales, and the time the job responsibilities were changed. 18 months, as this court said in Roberts versus Glenn Industries, it not only did the facts of that case look at whether that was a proper inference.
If you explain to look at that fact, you didn't directly say the proprietor, but it alleged that he was informed that his knowledge of Murphy's conduct effectively conferred actual notice in conduct. How can you take an inference from that, infer from that, right, that he was in trouble?
Well, because the inference that plaintiff asked you to say is there was an 18-month period that those job duties were changed, and plaintiff says universities, it takes a while to go through that process. We can infer there was an investigation going on. But Your Honor, that's exactly the stacking of inferences that this court in Stone versus Liberty Mutual and in Kuhn said cannot be done. Furthermore, Your Honor, it's at odds with one of the allegations in plaintiff's own complaint. In plaintiff's complaint, paragraph 72C, Joint Appendix 26, plaintiff says there was no investigation. So plaintiff is asking this court to not only stack inferences, to merely speculate regarding why there would have been an 18-month period, but to do that, to then conclude that that's at odds with their own allegation in the complaint. That this complaint, we have to look at the four corners of this complaint. We also find the same problem with the actual notice. Here, the allegations in the complaint are that Finley told Clink Scales that Murphy was engaging in what he suspected was sexual grooming of student athletes. Suspicions are simply not sufficient, as the district court held.
Why is it not sufficient? What Coach Finley had said was, I suspect that Murphy is sexually assaulting student athletes. That's still a suspicion. Would North Carolina State have done nothing?
Well, Your Honor, it is a suspicion. It's closer to the rumor and gossip of Fairfax, but even sexual assault, we look at the court in Ross versus University of Tulsa, the 10th Circuit says, when you look at whether an allegation of notice is too vague or not, you look at the facts, the who, the what, the when, the where. The university needs enough of those facts in Fairfax.
So to answer my question, if Coach Finley had said, I suspect that Murphy is sexually assaulting student athletes, North Carolina State, under your reading of the case law, didn't need to do it.
Well, Your Honor, that is a much closer to notice. It's still hard, but I think that is a Yeah,
How do you define sexual grooming?
Your Honor, that's the problem. There is nothing in the complaint that defines sexual grooming. It is a vague term, it's a label, it's ambiguous. To use this, if we were talking about pleading standard, Iqbal talks about a naked assertion devoid of factual enhancement. Grooming, that's the problem.
Is there something about the phrase sexual grooming that is innocuous, that doesn't give some indication that it's predatory? That what is the goal of sexual grooming?
Well, Your Honor, it is a very charged term. I agree with that. The problem is that it is not defined. There are no facts in the complaint that tell us what it was.
So Coach Bentley provided a suspicion of a very charged term, and North Carolina State was not on notice that there might be an issue. Is that your argument?
Not for Title IX. I think we can probably all agree that there should have been some more questions asked, or there should have been something done.
If Coach Bentley had said instead of I suspect, just leave off the I suspect, Murphy is sexually grooming student athletes, would that have been sufficient notice to the university?
Well, Your Honor, those are not the facts we have here.
Right, I'm just asking you, your problem is with the word I suspect.
It's with both suspect and groom.
So sexual grooming would be fine.
Both.
An allegation of sexual grooming would be fine for North Carolina State?
It is not fine for North Carolina State,
Okay.
but it does not provide the actual notice that Title IX says that it has to be provided.
So what would Coach Finley have needed to say in this circumstance to provide actual notice to the university?
Well, we don't know, Your Honor, because we don't know any facts beyond this. But there would have needed to be notice of sexual harassment, of sexual misconduct.
And sexual grooming is not sexual misconduct in the view of North Carolina State University.
Your Honor, this court and I here must look at the complaint itself, and there's nothing in the complaint to say what that sexual grooming is. Sexual grooming could be any number of things. And so because we have no other facts to provide that enhancement, that factual enhancement, the court is left with the same issue that it was on the appropriate authority. The complaint is simply not sufficient to provide that notice required under Title IX.
Does it matter, given the fact that it is a charged term and there's a range of conduct that has to be taken as the images from this, or not this, and this, and more varies, where the pleading said, most, if not all the cases that you need to do, or the summary judgment statement, why doesn't the benefit of that
because, Your Honor, that's what courts in Iqbal and Twombly have said is not the case, that plaintiffs must come forward with enough factual enhancement for the court to make that conclusion. If we literally took that to its full result, we would say that for every 12b6 case. Every 12b6 case, we would sit back and say, let's let discovery play out and see what the facts are and see whether there's a claim.
In certain cases, however, which it would be dealing with sexual harassment, it's not like the drug case we talked about earlier, that we were talking to all the time, to change the world. I'm not proving that, but as Judge Diaz alluded to, is when you use a term, you say we don't have all the facts, we don't know, but the term is date. I mean, that's what a discovery is for. That is what summary judgment then comes up when you deal with it, as opposed to the pleading. You say, well, you just made the speculation of students, sexual students. He didn't just say students, he said student athletes, which tells you there's more. It's like a pattern. And you got the senior person, at least in the title, telling someone else that, oh, give this to the same person. And the question, this going back to the Sacker's question is, what is the response to that? And let me just also point out, when you mentioned the Fairfax case, the Doe versus Fairfax case, in that case, we made clear that the possibility of a sexual harassment relationship is sufficient to put that school board on the Fairfax is pretty much a game changer on that. Right now, it's still good law. I don't really think it's changed that. So, I mean, doesn't that apply here? At least, again, with 12B6, I was saying, when you get to summary judgment, that's a tough case. I think there's some facts that could come out, but it can come the other way too. But 12B6 is just that. And I don't think Iqbal Twombly intended for to keep plaintiffs out of court because of specific type things that it would have in this type of case. What do you know?
Well, and I apologize, Your Honor, you said something at the beginning that did not, I'm sorry.
That happens to me.
But there is not enough here based on Iqbal and Twombly. If we go back to the district court, if we look at the facts in Gebser, the allegation was that parents had come forward and had made complaints that the teacher was making. No, it's a summary judgment case.
They keep that same.
Well,
you're talking, summary judgment, not 12B6.
Yes, Your Honor.
It's dealing with a whole different standard.
The cases that are most known in this area are summary judgment cases. There are certainly a lot of unpublished cases, and some published. There's an 8th Circuit case with, I believe it's Culver University, that it's at the 12B6 stage. And if we say to plaintiffs, you don't have a pleading burden at the 12B6 stage, we risk going through discovery when there's not enough there. Our courts have noticed pleading for a reason and say that you have to meet a certain burden at the outset.
On the 12B6 stage point, the second prong of actual notice to someone with corrective authority, which the district court didn't address. Were you saying that if this case is sent back, appellant would not or should not or could not have the ability to amend the complaint if necessary on that corrective authority?
Well, Your Honor, if the court
I understand you said you have had several chances already.
If the court were remanded, then maybe plaintiff could. I don't know the facts that are there, but certainly plaintiff had that opportunity. But I don't know if there are the facts that they could do.
It was dismissed without prejudice, correct?
Yes, Your Honor, it was dismissed without prejudice, and plaintiff took no steps at that point or to reopen so that they could file. Your Honors, it's also very important to remember that in Gebser and Davis, the court said you cannot find actual notice based on constructive notice. This is an actual notice standard. When we talk about what a court should do, what a university should do when it gets notice of sexual misconduct or of grooming, that is the standard for negligence. If we look at the Boehner decisions, the court there says Malone, principal in Boehner, should have had notice, but the fact that it did not was not sufficient. We know what NC State does when it has notice. That's in the complaint. When Locke said, I have been subjected to this conduct, NC State immediately launched an investigation. Murphy was suspended, and that investigation followed. I'll end where I began. NC State does not condone sexual misconduct of any type. The question here is a legal question for the reasons stated.
Not here. No one believe that. That's not the issue. The issue is one that's dealing with 12B6 and whether there's sufficient notice. If you make an allegation, sexual grooming, if you say it's against athletes, question, you assume this is an authority that can do so, is that sufficient at a 12-6? This is a legal question. It may be interpreted by the media and everything else as being more than what it is, but it is purely a legal question. It is not saying anything about the conduct of NC State or any of the individuals. It's just a matter of which it's done. I just want to make it clear because it sounds good to say that. I know that's a good argument, but that's not what's before us. We're not answering that question at all. Or make it in the statement, just to be clear.
Your Honor, I see my time has expired. May I? Well, thank you, Your Honor. I agree. It is a legal question. For the reasons stated, we ask that this court affirm the district. Thank you very much.
Thank you, Your Honor. I'm just going to make 3 or 4 points in front of it. The first is, you know, I think my colleague, Judge Thacker, reviewed, I think the rule they're asking for on actualness would just be a real problem. I don't think any of us want a rule where even saying, you know, we suspect that someone is, you know, about to sexually assault a student, where that would not put the school on notice. And, you know, I think that's also just, as Judge Wynn's question also got at, I think that's foreclosed by that practice.
I'll be clear in terms of the end of the case, the judge without prejudice, but you didn't do anything. But the issue is the appropriate authority from the judge assumed. Trying to understand the import of that is whether you've already assumed it, but no need to, you assume it. But the question is, should you have done it anyway?
That was going to be one of my other points, Judge Wynn, and I think that's it's complicated when the judge also goes at the same time, because moving to reopen a different standard than amending as of right, and I think that putting the onus on plaintiffs to seek this sort of extra discretionary step to reopen is just it's just hard. And you know, as part of that response, I also wanted to push back a little bit on a point that the colleague made, which is that, you know, saying, oh, they had multiple chances to amend. That's not really true, not least because you can't sort of lump all these plaintiffs together. And for the second reason, there's, you know, the real reason that you would want the chance to amend is after a judge, not just, you know, the opposing counsel filed their brief. You want the guidance from the judge and their opinion about what the judge thinks the deficiencies are. And there was no opportunity where all these deficiencies on the same day in these other cases. And so there was no opportunity to amend with guidance from the judge. That's exactly what the district court thought.
Was there an argument between the district court that, by the way, that I think it was quite significant
I'm not sure of the answer to that. It's not in the record. And so I'm not sure of the answer to that. But I think that, you know, when you think about the sort of the way that this all happened, where, you know, opinion comes out, case gets, you know, judgment gets issued, case gets closed the same day. You know, I think putting additional responsibilities on them is just difficult. The third point that I wanted to make, while I still have time to do so, you know, my colleague talked about sort of what they regard as inconsistencies in the complaint, including that you know, they alleged that there was a failure to investigate. That's not quite what the complaint actually says. If you actually look at that paragraph 72 on J2566, it says that you know, they didn't investigate Finley's knowledge in a timely and meaningful manner, according to include what's familiar. And so I think that that's actually not that's not even inconsistent with the idea that they might have gone through some process that resulted in, as the complaint directly alleged, adjusting his duties to give him less access to male student athletes. Although again, leaving him with access to John Doe, a bunch of other student athletes, and an entire team of athletes, which is a real problem. Unless you have any other questions. Yes.
Thank you, Mr. Davis. Thank you. I'll thank both counsel for their fine arguments this morning. We'll come down to meet the counsel. You may just pop in the back and.
This honorable court stands adjourned, sign and die. God save the United States and this honorable court.